Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we're a law firm that works solely on technology, cybersecurity, and legal issues. In each episode, we look at stories in the law relating to digital technology from around the world, with an emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright. We're just going to be running through some stories that have been coming up this week. So I will pass over to Peter to introduce himself, and then we'll get started.
My name is Peter. I'm a solicitor and the managing director at Digital Law, and we've got a lot of stories to get through today, so I'll pass back to Amelia to kick us off.
Paeter. Thanks, Peter. So we are starting with one of the big hitters, and that is Meta. So Meta's decision is irresponsible and will prevent thousands of paedophiles from being arrested. As a parent, it's morally reprehensible. Meta is putting profit before the safety of protecting children from predatory sexual abusers. Fairly hard-hitting statement there that they've come out with, and pretty interesting story to go through. And if you are a regular listener of the podcast, you'll have heard us talking increasingly about parents' rights and protecting children from online harm. And today is one of those days we're going to be going through a few stories about how kind of the big social media giants are handling specifically like the online safety bill that's just been released here in the UK.
Indeed. So we've got this, well, it's now gone from being the Online Safety Bill to the Online Safety Act. And after 6 years of work, the whole idea was this was supposed to make the UK a safer place to go online, in particular for children and those who are more vulnerable. Yet instead, we've now had an arbitrary move here by Meta to bring Messenger in line with WhatsApp, its other messaging app. So this is basically the Facebook Messenger that I'm sure a lot of people will be quite familiar with, and it's a key part of Meta's online empire. And they have decided to now encrypt all of the communications that you have on there. You might say, so what? The problem here is that in its current form, it is messages on the Messenger platform that very often end up forming the basis for evidence that then is used by the police in their investigations in order to capture those engaged in paedophilia online, grooming, etc. Because basically these platforms take the view that, oh, well, we shouldn't have anyone below the age of 13 on here anyway, but the controls they have to prevent that are very, very lax. So children are on there and they are then approached and groomed by adults. So at the moment, a lot of the actual evidence that the police are able to gather from things like Messenger is some of the hard evidence that you can then use in court to show, well, look, this is what's happened. These are the messages were sent. This is the time it was done. This is how it contravenes various bits of legislation around this, even when it comes to online communications, and then you can secure your conviction. On the face of it, by having encryption, this will mean that it is more difficult for the messages to potentially be accessed by the police.
And that's just kind of one of the main key issues. I mean, we could stay here talking for ages about the controls that are involved and why really this is not the best plan. But this very nicely links into our next story. And this is looking at TikTok. So again, one of the other big social media giants. So TikTok is being investigated by the UK Communications Watchdog over providing it with inaccurate information. And I think one of the big things to flag here is that this is not the UK Information Commission's Office, so it's not the UK Data Protection Regulator. We are looking at information that was contained in a report for Ofcom. And that is where they were looking at TikTok and the controls that parents have when their children are using the platform.
Yes, this is, if anything, the more scary one, because TikTok has a much younger user base compared to Meta's. Meta relies on Facebook. Most of its users opened their accounts a good sort of 10 to 15 years ago, and its user database, while large, is growing older. I'm afraid all the kids, they don't rush to go and open a Facebook account. They rush to get on TikTok and have incredibly powerful content streamed to them via TikTok's app, which serves them what they want, when they want, on a never-ending scrolling stream. The problem here is that, and this is okay. The Ofcom has picked up on this, but this isn't the first time that TikTok has had problems with regulators when it comes to the provision of the service and making sure that it is not harming young users. And of course, technically, you shouldn't have children on these platforms. So it is an effort to look and say, well, look, what measures do you actually have on here to limit the content that can be potentially seen? And in this instance, Ofcom saying, well, we actually aren't particularly satisfied with the disclosure that we have been given on the measures that are supposed to be on there. Do you want to just take us through, Amelia, some of the actual, the sort of specific issues that Ofcom has got?
Yes, thank you. So Ofcom asked TikTok about its parental control system. I quote, but have reason to believe the information is provided was inaccurate, is what Ofcom wrote back. Apparently, TikTok was asked about its parental control system called Family Pairing, which it introduced in April 2020. And so this system allowed parents to link their account with their child's and manage things such as screen time, direct messages, content filtering, and privacy settings. However, under 18 users can deactivate family pairing at any time, but parents get a notification if they do. So it's a bit of a wafty sort of tool. It's kind of what I'd use there.
It is, and sounds like, as they say, that they have seem to have reason to believe that that's inaccurate as well. And it's the fact that, this is on here, but the under 18 can deactivate it. But the parent will be notified. I wonder how many parents carefully read through their notifications and would get the fact that that notification from TikTok means that it has been deactivated.
Well, that's just it. I don't think it would. I mean, bless her, my mum, love her to pieces. Can she understand her notifications on her phone? Absolutely not. 20 times a day what they mean? Yes. And I'm an adult, therefore this doesn't apply to me. However, if children are then saying to their parents, oh, don't worry, mum, that's just, just a random notification, is it really going to hit home? Probably not. And therefore the tool isn't doing what it was designed to do, to give parents control over what their children are seeing.
No. So on the face of it, I think if this is the sum total of TikTok's attempts to monitor this problem, I think we'd say it's not very impressive. But then obviously Ofcom is somewhat concerned that the disclosure they've had detailing how that system operates may not be entirely transparent either. So interesting, Ofcom have picked it up, and what are they going to do about it will be the next thing.
Definitely, I'm sure we'll end up covering that in the near future because it is in fact the gift that just keeps giving. So moving slightly away from the UK now, we are moving to the US. So a federal court jury has decided that Google's Android App Store has been protected by anti-competitive barriers that have damaged smartphone consumers and software developers, which is dealing a blow to a major pillar of the technology empire. So the unanimous verdict reached Monday came after just 3 hours of deliberation following a 4-week trial revolving around a lucrative payment system within Google's Play Store. The store is the main place where hundreds of millions of people around the world download and install apps that work on smartphones powered by Google's Android software. So this is quite an interesting one. Peter, you have to unpick this further.
Yeah, I mean, I think in particular I think the first of all we need to mention the fact that this is a piece of litigation launched originally by Epic Games, the producers of Fortnite, which I think is the world's most popular game that's played on mobile handsets, for example. Incredible number of users and take up. And of course, every single user that gets hold of the game is done through through an app store, either on your iPhone or in this instance on Google. And interestingly, a parallel lawsuit that Fortnite Epic Games brought against Apple failed in 2021. However, this one, 2 years later, has gone through. Both of these are federal decisions, though the Apple decision is now in the process of being appealed to the Supreme Court. So in the context of that appeal, we've then got this decision that's now been made with regards to Google. And in this instance, it's a very rapid decision that was made, just 3 hours of deliberation. that is pretty much unheard of in big technical trials like this, let alone the fact that it was unanimous. So it seems here as though the arguments must have been very effectively and cogently made, and indeed the software developers clearly were not able to advance a particularly convincing defence in terms of the reasonings, in terms of how the app is downloaded, how it's sold, how any in-app purchases are carried out, and how Google then takes a percentage of that. So I think another interesting thing on this is I read the story the first time, and then had to sort of go back and remind myself that this is a decision of a US federal judge, because, well, a US federal court rather, under the management of a federal judge, because it reads almost like what you'd expect to see in a decision of a court in Europe, and the European Court of Justice, for example. So the fact that this is happening in the US with regards to practices from, in this instance, Google as a large US tech firm, alongside Apple as one of the largest firms in the world. And it's just fascinating that such a decision has been made. Now, you can already, given that Apple decision is being appealed, the same thing could happen here. So this decision could end up in the Supreme Court, and then we'll still have to then look and see what the Supreme Court says about Apple before we get any sort of real definitive positions on this. So we do have to watch for where it goes next. But the fact that this decision has been made could end up being incredibly significant in the long run in terms of a greater level of intervention by the courts in the US with regards to the ways that the large US tech firms carry out their business with regards to practices that here so far, before now, were accepted as simply how they've carried out business. They may now find that they are not compatible with the way that these practices, they are simply not going to be acceptable in future. So will this decision stand? If it does, this is really, really big. It's huge.
Thanks, Peter. So moving on to our next story here, we are looking at the Financial Conduct Authority, and they have taken more than 3 years to crack down on illegal crypto kiosks in Britain, according to an official report that raised concerns about the sluggish response of the regulator to new financial threats. So the National Audit Office said there could be a significant delay between the FCA identifying an issue and it taking action, and pointed to failure to act quickly on so-called crypto automated teller machines as an example. I think this is very interesting in the sense that actually they're not really moving with the times here, the FCA. They're not really understanding the effects that a crypto kiosk could have and moving quickly enough to tackle it.
Indeed. I hate to sort of jump for a well-worn phrase and trope here, but this unfortunately does smack a little bit of closing the door after the horse has bolted. Because, of course, the big era on the face of it of crypto investment and speculation peaked last year, shortly before the collapse of the FTX platform, and indeed Binance, which is now left as the world's largest cryptocurrency trading platform, is also experiencing a few problems as well. And an awful lot of people lost an awful lot of money in the crypto bubble that developed last year. That's not to say that there's still an awful lot of money invested in various crypto platforms. Indeed, Bitcoin seems to be the one stable currency that still is holding on to a significant amount of its value, and indeed, I believe is still increasing, albeit somewhat more slowly compared to how it has grown in the past. But nonetheless, the issue here that being highlighted is that, that this is highlighting the fact that the FCA took 3 years to actually take definitive action in relation to these crypto ATMs, which were starting to develop all over the country. particularly during lockdown. And that was incredibly dangerous, given the restrictions that were placed on interactions in the physical world in 2020. An awful lot of people did go online. An awful lot of people did start to make decisions thinking about, oh, this could be a life-changing opportunity if I put some money into crypto, or I end up taking out a crypto asset or an NFT. This could be the big game changer. Um, all of this was taking place, and yet, for example, these actual crypto ATMs, automated tellers, were being set up, and it's taken 3 years for the FCA to actually work out that the providers of those ATM machines were not actually registered with the FCA, do something about it, and then actually carry out some enforcement.
I think the key thing here is the fact that this particular article goes on and says, well, the Public Spending Watchdog pointed out that city regulators have required crypto asset companies to comply with anti-money laundering rules since January 2020. So, we're in December 2023 now, so 3 years on, and had engaged with unregistered companies since then. They had only begun enforcement action against illegal operators of crypto ATMs and shut them down since this February. So we are still talking about 3 years that it's taken to do this.
Yeah, and there seems to be a range of either people not necessarily understanding these developments within a fast developing and innovating crypto sector. It looks like there's been problems with the regulator in terms of high staff turnover, so you've not got a sort of level amount of expertise in different departments and teams, which is going to affect their ability to understand and regulate fairly in what are compared to potentially quite complex areas, certainly for administrators within the FCA who are not experienced with this type of technology. So that kind of highlights here the failings of the regulator that have led to this failure. And it's to be hoped that the lessons will be learned as a result of what the National Audit Office has said here. Because after cryptocurrency, you can absolutely guarantee it'll be something else. Crypto will continue to be an issue. And I've already talked about NFTs. There are various other bits of innovation happening all the time. And it is important that if a decision is taken, for example, oh, these should be registered in some way, shape or form, or regulated in a certain way, then it's important that the regulator actually does that. And having those sort of systemic problems in terms of rapid staff turnover and headcount simply aren't going to be acceptable, particularly when it still remains the case that you're looking at developments within financial services within the city still forming such a large part of the UK's overall economy and gross domestic product. So in order to have confidence in the UK's financial services sector, you've got to have effective regulation from the FCA.
Thanks, Peter. So moving on to our next story here, we are looking at a city firm and whether they acted lawfully by dismissing a trainee solicitor who has sent up to more than 100 work emails to a private account. So the London Central Employment Tribunal has ruled. It found that Sterling Lawyers Limited was justified in dismissing an individual just over a year into her training contract over the email data breaches. And this is where it's quite interesting because it is in fact a data breach to send emails to a private email, especially if they are containing confidential client information and you are sending them outside of what I would hope to be a secure system. However, as we have seen in previous weeks, not all systems are as secure as they might seem to be.
Indeed.
But this is kind of a big flag for us to take a look at here.
It is. I think it's important to bear in mind that this is an event in the Employment Tribunal rather than the SDT. So it's not as though this solicitor found themselves facing regulatory enforcement from the SRA for this act. But nonetheless, and well, I think the other thing we need to just highlight here as well, actually, is that this was one piece of conduct amongst several bits of conduct that led to this solicitor being dismissed and then the Employment Tribunal saying, yes, you as a firm did act lawfully in dismissing this trainee solicitor. The thing with the work emails is absolutely, as Amelia has said, but I think we probably just need to, I suppose, just detail the fact again for the avoidance of doubt that when you've got email still, arguably incorrectly, but you know, it is still a tool that is relied on by the majority of law firms for undertaking their communications with clients and third parties, even though email has numerous security issues, such as this one. The problem is that for whatever reason, it looks like, did this trainee end up forwarding all of this? Did they perhaps they automated and forwarded this stuff automatically? So, for example, any emails received over the weekend, I'll have them forwarded to my Gmail account, or maybe they just received them and forwarded them or copied them to a private account for whatever reason. But the point is that those work emails were forwarded from the work server, the firm server, to then their private server, be it something like Gmail, Hotmail, who knows. And if that happens, that is a breach, a data protection breach. It's also a breach of confidentiality. And we know that the SRA, and through its enforcement in the SDT, has come down very heavily on solicitors who've done that in the past. And in this instance, they've said it was just the sort of act that would justify this trainee solicitor being dismissed. So, just for the avoidance of doubt, I'd say this whether you're working in a law firm or anywhere else, if you are tempted to forward work emails to, say, your Gmail account or Hotmail account because it's easy and then you can access them on your phone when you're out of the office or when you're doing whatever, I would think very carefully about it. In fact, I wouldn't think carefully about it. I wouldn't do it, to put it bluntly. So bear in mind that there are free tools out there, such as your free private email account or your free personal Dropbox or Google Docs. Those are designed for personal use, not for business use. You should not be using them to store your firm's documents on, your employer's documents, etc. That is not what they should be shared on. And you are running a real risk of either, at the very least, regulatory sanction and enforcement, as well as potentially an internal disciplinary at your employer, and at worst, you're going to lose your job. And potentially even worse than that, you could then, as a private individual, face a criminal legal action that could put you in prison, depending on the size and volume of any personal data that is involved. So, for avoidance of doubt, don't do it.
Thanks, Peter. Moving on to arguably one of the scariest stories I've seen possibly this year, and we are looking at Amazon. So spy cameras disguised as clothes hooks are for sale on Amazon, despite the firm being sued over the gadgets. One clothes hook camera listing seen by the BBC features a picture of the device positioned in a bathroom. So a US judge recently ruled the retail giant must face a case brought by a woman who alleged she was filmed in the bathroom using a clothes hook purchased from Amazon. And a privacy expert has said that the misuse of such devices may break British laws. I think here as well it's important to mention that at the time the alleged victim was a child when this happened. So, it's bad enough thinking that a clothes hook is recording people without their permission, but we are now talking about a child in a bathroom.
Yes. And I think the problem here is that you've got technology that really can't be used for anything else apart from covert surveillance being easily marketed and available on a popular worldwide platform, and that popular worldwide platform not really doing anything to actively look at the content that it has on there or that its resellers have got on there and say, actually, I wonder if this is entirely legal or even conduct that should be encouraged. Admittedly, for such a large shop window to the world, generally they're not supposed to, for example, sell anything that could encourage, criminal acts, terrorism, download a gun, buy a gun or a 3D printer instructions on how to build a bomb here. But when you've got, as I say, equipment that can't really be used for anything else, the point here is that it will be a narrow matter for the US District Court in Virginia to look at this and see what it thinks. Amazon, of course, is saying We provide the platform, not our problem what's being sold on it, not our problem what it's then used for. But as I say, difficult to see what else it could have realistically been used for. What fair, legitimate thing would you have used that covert camera for? And you do get quite a bit of equipment like this. I have seen that, for example, there are things that look like phone chargers that you can plug into the wall, that actually end up containing cameras and recording equipment. So there is clearly quite a sizable cottage industry out there producing this sort of stuff. I was also reminded of the issue that we've reported on this podcast before about Apple AirTags. The idea being you can put an AirTag on your phone or your keys, and whenever you can't find them, you can then go on the app and you can find your keys because it's got the Apple AirTag on. But of course, what was it being used for? It was then being used for surveillance, principally men surveilling women. So you'd suddenly find, women were finding, oh, there's an AirTag being found on the bumper of my car, or an AirTag being found in the rear passenger footwell, or an AirTag that's been dropped in the handbag. And it brings out, unfortunately, a rather dark side of the human psyche that wants to engage in this sort of activity. And in that instance, a sort of a fairly innocent tool could be used nefariously like that. But in this instance, you've got a tool that can't really be used for anything apart from fairly nefarious activity, certainly to invade someone's privacy and record them in a place where they probably thought they would have been in private. Final point, of course, in this instance, it's the fact that it's then being used to record minors. Not only is that, of course, thoroughly reprehensible and unpleasant, it's also, I'm afraid, with Amazon, it's kind of, and it's a little bit going back to the Facebook and TikTok things we were talking about earlier, where you've got the technology being used for that unintended consequence, and just the fact it's being used for an unintended consequence doesn't absolve you of responsibility for what it's being used for. And in this instance, the Amazon platform is being used to put children at risk, minors, at risk. So that is now something for the District Supreme Court in Virginia to look at.
Certainly something for the US to look at, but interestingly, when the BBC conducted their research for this investigation, they said that they could find similar cameras on Amazon.co.uk, as in these are available to buy in the UK, and I wonder whether in the future we'll see increasing stories of these being used for nefarious purposes in the UK in the future.
I'd be surprised if we didn't.
So moving on to our next story, just trying to not think about that one too hard, to be honest.
Indeed, yeah. Let's talk about something nice instead.
So as we approach Christmas, you're probably sick to the back teeth of hearing about different supermarkets advertising. We have the cheapest carrots.
Yeah, well, here we go. Let's talk about commercialism and the sale of personal data. This will be nice.
Yeah, exactly. So much happiness went on. Yeah. So Tesco's and Sainsbury's are Britain's two biggest supermarkets. They are estimated to be making 300 million a year from selling information about their customers' shopping habits and choices to consumer giants and TV companies. So the companies such as Channel 4, PepsiCo, Heineken use the data to understand consumer behaviour and to target people with advertisements linked to the products that they are likely to buy. So every day supermarkets are collecting a treasure trove of information, from monitoring to what people are buying using a Tesco's Club card or a Sainsbury's Nectar card. So the widespread use of the loyalty cards provides supermarkets with a hugely valuable set of information about their customers, such as whether they have children, whether they're vegetarian, or prefer Tony's Colonies chocolonis, I can't even say that, or Lindt chocolate. You get the idea, what sort of things that they are buying. I mean, crikey, I'd love to know what
just say Lindt or Cadbury's.
There we go.
That would have been easy.
I'd love to know what my supermarket thinks about my shopping habits, because crikey, I shop like a 70-year-old. I don't buy anything that interesting.
The thing here is it's almost confirming the sort of Big Brother fears you may have had. Tesco has been collecting information on its users through its club card scheme for 30 years. It's not a new thing. Nectar is a sort of similar age. Interestingly, the approach of the ICO, the Information Commission, has always been, well, if data is anonymised or pseudonymised, data protection laws fall away and they don't really apply, because you then can't identify people is the principle at play there. So in this instance, Tesco and Sainsbury's, they aren't doing anything illegal. They are merely saying we have anonymized the personal data. So the idea is it's not as though they're selling people's names and addresses or email addresses or IP addresses. They are merely selling information where that personal data has been anonymized or pseudonymized to then, for example, streaming companies, Channel 4, Netflix, saying, well, here are some general users and we've got these indicators as to their preferences. So hence, do they prefer the Lindt or Cadbury's, etc. Or do they prefer to drink Stella or Heineken? It's those sort of general patterns. The idea is that information is then used for targeting, for some very specific targeting when it comes to adverts on those platforms. What I think is interesting on this, and it will actually be whether any of these practices can be challenged, because what the law actually says is that it doesn't actually say what is or is not personal data. It just says personal data is what allows an individual to be identified. So hence a name, an email address, a home address, car registration number, a photograph, a video recording. So for example, this video recording now contains personal data. You can identify me and Amelia from the fact that you can see it if you're watching the video of this, or you can hear us with our unique voices. So that's personal data. In this instance, a view seems to have been taken that, we can work out who an individual is. Well, we can sort of segment an individual in terms of what we think their preferences are, and then pass the information of those preferences on to a third party. So that third party can then use it for segmented and targeted advertising. But in order to do that suggests that you would then have to have you'd be able to sort of have to have a fairly good idea when you're looking at individual user accounts. So say your Channel 4 streaming account or your Netflix account. Would that, for example, mean that you would be targeted based on those other preferences? And if you are, doesn't that mean that you're being identified through that streaming account? And I don't know if that's necessarily been really thought through by those undertaking this transaction. They seem to have just thought, well, what is it that's personal data? Well, I don't think that someone's Netflix account would mean it's personal data. But the whole point here is that, and I'll just read it to you here, the tie-up here, is the idea is that you tailor advertisements on a streaming platform to groups of users based on their recent shopping habits in supermarkets, meaning users will be shown more relevant ads from brands they like and want to see. This means that two people living in the same street, both watching the same program on an on-demand streaming platform, hypothetically the Great British Bake Off, would receive a different slew of adverts depending on what they had or had not purchased in a supermarket. So that's quite a sophisticated degree of targeting that's taking place there. And it is difficult to understand how that could be done without, to a certain extent, thinking this individual brought these items on this Nectar card, and then therefore we're going to show them this advert when they're streaming it on the Channel 4 digital platform. Does that entire transaction take place without, at some point, those individuals being identified? That would be the $60,000 question or more if that ended up being considered by a regulator or being placed in a court.
I think it does smell a bit fishy, if you ask me, because
though in a very real and legal binding way, we are not in any way casting any aspersions onto the legality of this deal. We're just saying, interesting if you were to apply it against what we know is within GDPR, UK GDPR, and the UK Data Protection Act. He says, quick disclaimer there, just in case anyone is, what are they saying? Well, we're just saying it would be interesting if this faced broader regulatory scrutiny.
I agree, and I think it's very interesting because from what I understand that happens in kind of day-to-day life, I find interesting the fact that my parents will be watching the exact same program as me. My parents live around 300 miles away. Therefore, they are a very different region as to where we are in Yorkshire. And they will get very, very different adverts, despite the fact we will be watching the same thing. And so to have the degree, the fact that, you could be watching the same program on the same street as someone and have different adverts baffles me. Because, yeah, you can understand regional difference. If, you buy more potatoes in Yorkshire, you'll get more potato adverts.
Yeah.
But to that granular degree.
Well, just to give you an example, using a well-known podcasting platform, I was targeted this morning with an advert for Currys,
Oh, right.
saying, "Oh, we currently have these deals on mobile devices. Available now at the Currys in Sheffield, near Healy." So you know where I am in that case. So I'd be interested to know the degree of targeting that's taking place there, because that isn't just that streaming platform thinking, oh, your IP address is in Yorkshire, so you're going to get a Yorkshire advert. That was a really specific, you're living in the centre of Sheffield, therefore we're going to serve this at you. And the fact that it was technology related means they probably have a fairly good idea what I do for a living.
Either that or they just enjoy listening to the podcast.
If they do, hello.
I do think it's very interesting. I do think we're going to see more regulators coming down on this sort of thing. I think this year there's been a big focus on the online safety bill, which is now the Online Safety Act. Do you think now the regulator is going to be looking more wider afield at advertising and how this is affecting the generalised consumer? Because this is maybe the second or third story or big story this year that's looked at how advertising works in terms of data.
I think the only way that the regulators would get involved is if they were sort of almost dragged kicking and screaming. But I say that from the point of view that when they've got a lot of issues at the moment around things like online harms and safety, do the actions of organisations in terms of data sharing deserve the focus and the attention of the regulator? Well, arguably it does, when you think that, for example, the ICO recently was saying, well, we're going to start cracking down on organisations over their use of cookies.
Yeah.
Because so many organisations still do not have the correct information in place when it comes to cookies and cookie banners and transparency. And if you'd like to know more about the legalities of what's actually required, do get in touch. We'll tell you. But the point is that there seems to be a lot of confusion out there. We've still got a lot of very confusing and arguably over-engineered banners that actually screw up the user's experience, and will just put them off using particular platforms and portals. Yet, the ICO is saying in many instances this actually isn't what's required under the law, and we're going to carry out regulatory enforcement. So, if you can have the time to start doing regulatory enforcement on cookies, then you should also be looking at some of these bulk data sharing agreements that seem to be taking place, and thinking, well, does this really meet the letter of the law? How are they applying the anonymization and pseudonymization? Are people being targeted to such a high degree in a manner that is entirely consistent with application of UK GDPR and the Data Protection Act 2018? I'd be interested to know.
So that was our last discussion for this episode. If you'd like to hear more from us, including subscribing to our newsletter, as well as receiving information about subscriber-only podcast webinars and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you to Anson Evaluate for helping to produce this podcast. And if you'd like to produce your own podcast, webinar, or you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com. Just a reminder, these episodes are available on our website, YouTube channel, podcast channels such as Spotify, Apple Music, Amazon Music, Google Podcasts, and please feel free to leave us a review. And finally, if you have any questions about anything that we've talked about today, please feel free to email us at admin@digitallawuk.com. Thank you for listening, and we hope to see you again next week.